Welcome to the Let's Talk Politics Alabama podcast with your host, Daniel Stover and Russ Sanders, where we take a look at Alabama politics like a drive down I-65 from North Alabama to the state capital in Montgomery and all the way to the Sugar Sand Coast.
I will not make age an issue of this campaign. I am not going to exploit, for political purposes, my opponent's youth and inexperience.
I'm Kay Ivey, but there's no step too high for a high stepper.
We choose truth over facts.
I don't want to speak negatively. I said, though, that if I lose this election, maybe I'll end up moving to Alabama.
Someone has once said that actually, as long as there are final exams, there will be prayer in schools.
All right, welcome back to the Let's Talk Politics Alabama podcast with Russ Sanders and Daniel Stover. Russ has actually tried to put a little bit of oil on his chair, so we can't call him Squeaky anymore.
It's still squeaking though.
All right. Well, this week we're joined by Judge Mark Craig, who is our local Lawrence County circuit judge, and we're going to talk a little bit about his reelection campaign, what the circuit judge does, and you know, just try to get a better understanding of the court system. So, Judge, I'm going to let you take and kind of tell us about yourself and how you became circuit judge, your history of where it all started and why you wanted to become judge.
All right. Well, of course, I was born and raised here on our family farm and graduated from Hatton High School, but sometime during high school, I attended a career day at which Justice Renaud Allman was the only speaker. I mean, he was the speaker, but I think I was the only one listening to him. And he came up to me afterwards and said, "You really need to go into law. You really need to go into law." And I was going to be a chemical engineer up to that point. And so I changed my aspiration, and Justice Allman helped me throughout with character references and things that are necessary to pursue a legal career. But always a sort of a careful kind of have a backup plan. So when I went to college, and I realized a pre-law degree is no good if you go unless you do anything other than go to law school. So I pursued a degree in accounting. I really loved accounting. In fact, I almost changed again. I thought I might be an accountant because I really loved it. But I stuck with my plans. I went to Auburn University, where my dad went, and my brother went, and my uncles, and my future brother-in-laws, and just a lot of Auburn people in our family. And so it was never in doubt where I would go undergrad. But when I came out of law school, out of college, I wanted to sort of stretch my horizons a little bit and see if I could get into what was then a top 10 law school, and that was Vanderbilt. It came down to Vanderbilt and Washington Lee, and Washington Lee is a very nice place. I encourage you to visit there if you've never been, but a little too far from home for this guy. And so I spent 3 years at Vanderbilt, got my degree, and joined the law practice of an established lawyer in Decatur. I actually tried to get in with some of the law firms here in Moulton, but they didn't have any openings apparently. And but this guy had strong Lawrence County connections in that he used to be our state senator. When there was a time when all of Lawrence County and all of Decatur constituted one Senate district. And this man, Bingham Edwards, represented us, and he intended only, he believed in one term, and that's all he did. But as a result, he had a large Lawrence County practice, and we had a mutual friend in common, and that's where I started. And I practiced law, a general trial practice for 23 and some odd years, and did all kinds of work, both criminal and civil, and with a lot of emphasis on civil lawsuits of one form or another. I represented class actions on some environmental litigation and in voter rights cases. I just took on sort of an esoteric kind of view of challenging legal concepts. I also was an appellate lawyer. First, that came out of necessity because I was losing all my cases. I had to appeal. But then when nobody else loved doing appeals, I love appellate work and I love legal writing. And so did a lot of that. But in 2008, my brother, who had practiced with me for several years, decided after losing out on an attempt to get a gubernatorial appointment to a district judgeship in Decatur. By the way, my law practice office was in Decatur this whole time. I moved back to Lawrence County in 1997 and have been here ever since. But he decided he was just going to go for it. And he was a prosecutor in Bob Burrell's office, and Bob Burrell was one of the more accomplished Republican politicians in Morgan County history. And he had advised me. The downside with Bob is he had a very strict rule: if you run for office, you can't be a district attorney while you're running. So Brent had to just sort of survive on whatever he had saved up for the campaign and for his living. But I helped him in that campaign, and midway in that campaign, Ken Johnson, who I'd never met, from the Lawrence County Republican Party, called me up and said that there was going to be an opening for Judge Philip Rich's slot. When I was a kid and dreaming about being a lawyer, I thought I'd practice law for 25 years or so and then be a judge to close out my career in my home county. But Judge Rich was going strong. He was young looking. I didn't know how old he was. He'd just been elected to another term. I thought, well, that dream I'm just going to have to put on the shelf. I started having, clients that would pay the bills every month. I represented the city of Decatur and a lot of their outside work when they hired outside lawyers. So my law practice was really taking off. And then here calls Ken and introduces himself. And he said, we'd really like you to think about, putting your hat in the ring. I said, well, Ken, I'll have to think about and pray about that a lot. Because if I do, and you must assume this, if you're calling, I'd have to run as a Republican, and that county's never elected a Republican. And he said, well, we're counting on that you would run as a Republican. And so I thought about it after Brent got elected in November of 2008. I think I let them know that I would. And I can't remember the exact process. Judge Terry and a lawyer named Mike Terry also applied. We all had interviews down at the governor's office with the chief of his legal staff and a couple of others. I think his chief of staff also interviewed us. And the next following Monday, I get a call from the governor saying, you still want to be circuit judge of Lawrence County? I said, yes, sir, I do. And he said, well, you got it. And that's about all I heard from him. And I took over the very next week. I went to see Judge Rich. That was on a Monday. I went to see him on Tuesday. And his wife, tragically, was in the last stages of her battle with cancer. And so he did not want any kind of delay in my taking office. So I had to shut down a law practice of 23 years and learn how to be a judge. And I had less than a week before I started my judgeship. So it was a very stressful time, but by God's blessing, I was able to get through it. And been a judge ever since, and enjoyed immensely. Though the trials we've had, and I mean that in not a jury trial, sense, and the trials and the tribulations that we've experienced with moving the courthouse, which is something we do on average every 75 years or so, having a courthouse fire, dealing with the aftermath of the tornado in 2011, and then, of course, COVID. I've had a lot of unique experiences that no other judge before me has had to face. And, but, you take the times as they come. And I really enjoy being this county's judge and highly honored to be this county's judge. I wouldn't want to be judge anywhere else and have no ambition beyond, as far as the judicial ambition beyond this office.
Well, we're going to try to steer away from COVID questions the best we can. We've had some bad reactions with YouTube with that. So
yeah.
I did have a question. You were talking about the Senate judicial, or the Senate district, Decatur, Lawrence County. Didn't Lawrence County's own judicial circuit, if I'm not mistaken, ain't been around that long? My understanding is it was part of either Franklin or Limestone County or even Morgan County.
Oh, yeah. Yeah, that's right. You're exactly right about that, which means a lot of famous judges came through our courthouse when they were riding the circuit. In the Judicial Act of 1908, we had just 21 judicial circuits. Today we have 41 judicial circuits, but in those original 21, we were in a circuit with Morgan County, Madison County, Limestone County, Coleman County. And Madison County spun off in the 30s, I think it was, and became the 23rd Judicial Circuit. Then Coleman County spun off in the late 50s, and our circuit was created in 1965 by legislative act, but the position wasn't filled for a whole year because there was litigation on who could serve in that position. Our state representative, when he passed the law, fully expected he would get the job because he had a law degree out of Georgia and was licensed in Georgia, but he had never been licensed in Alabama. And that case went all the way up to the Supreme Court, and the Supreme Court ruled to be a judge in Alabama, you have to be a member of the Alabama State Bar. And once that was clarified, Governor Wallace, I think, at the time, yes, it'd be Governor Wallace, he selected Justice Renaud Allman, the man that I just mentioned. He remained on the bench only 2 or 3 years before he was elevated to a Court of Appeals job. And then, so Decatur, at that point, we became the 36th Judicial Circuit. Decatur still and Limestone County were still together. And then Limestone County finally split off. And now Decatur, the 8th Circuit, which was one of the original 20, still exists, but it's only Morgan County. So the judge in the Scottsboro Boys case, tried cases in our courtroom. Judge Bloodworth, who was a legendary figure on the Alabama Supreme Court, tried cases in our courtroom because they rode the circuit over here. And so we had local judges, like county court judges, they were called then. But in 1973, we changed completely our judicial system and how it works, and modernized it, and really became something other states try to emulate in our structure. It's very clean the way we've structured it.
Now, those judicial circuits, were they added because of population growth, or why was
Politics.
that? Politics. Okay. Well,
they saw that they could get their own judge.
Yeah.
And I called Justice Allman when I was doing a presentation about the history of the circuit one time, and he was still alive. He's passed on now. But he said, I tell you why I got that job. He said, nobody else wanted it. I mean, we didn't know what we were going to do. He says, I was 28 years old. And of course, if you ever look at Justice Allman's pedigree, if you will, I mean, his family they've been United States senators, not only in this state, but in other states. He was his family just involved in politics. And so he used as a springboard. When he left, then Judge Billy Burney was appointed and elected. And he served for 20 years. And then he retired at the early age of 52 and went on to practice law in Decatur until his death. And then Judge Rich was elected and served 20 years as well, which was at the time the amount of time you had to serve to retire and immediately draw retirement. So.
Yeah, I actually had Judge Burney's wife was actually, I think, my third grade teacher, so I actually knew a little bit about him. So.
Yeah, he's a Hatton guy.
She was there when I was there too.
Yeah, you got paddled a lot, didn't you, Russ?
I didn't get a paddle until the 10th grade. They said I needed.
It was a different day. I mean, I'm not saying judge because we're on the air, but some judges back in that day would actually go to sleep during jury trials, having to be roused, actually get up off the bench and go into their office. And the lawyers would have to knock on their door and say, Judge, we need a ruling on something in the middle of a jury trial. It was just a different day and time. They didn't even have a courtroom to give us initially. Judge Bill Lee, who was our long-term probate judge at the time, and Justice Allman had to fight over things like courtroom space and things of that nature. And when we built the new courthouse, Judge Burney came to see me and he said, I'll tell you one thing, if you ever want anything, you better get it now. Because it will be very difficult politically to get any other things that you need for the courtroom. And our courtroom is one of the more technologically advanced in the state under the guidance of Montgomery. They ask us to be sure and do that, and we have done that and kept it up to grade.
Well, going along with that, you're talking about all the different judges there. What are the duties or priorities of the judge, circuit judge?
Okay. Well, we handle in our unified judicial system, and we have the district court. You may be aware of that's Judge Angela Terry. She came into office just a couple of weeks after I did because Judge Mulliken retired. We ran on the same ticket. Both were very blessed to win in that November of 2010. But the district court is a non-jury court. So everything that's jury or jury related is in the circuit court. The district court has exclusive jurisdiction over all juvenile matters, which means I can't rule in a juvenile case if I wanted to. Mm-hmm. It's exclusive domain of the district court by law. Also, small claims cases are district court, and they're exclusive domain. Now, we have overlap in our concurrent jurisdiction on things like civil lawsuits up to $25,000. It was $10,000 for years. It was changed in 2019 to $25,000. I still have a lot of companies pursue collections or pursue lawsuits in my courtroom where the amount involved is $3,000 or $4,000. They could easily file that in district court, but a lot of them, just have other things in circuit court, so they can kill two birds with one stone, as it were, in coming up and covering those cases. So there's two components to a circuit judge's judging responsibilities. And those are bench trial type hearings, and then being the judge that sees to it that a jury trial is conducted properly. Bench trials will handle all workman's compensation cases, all unemployment appeals cases, and all divorce cases and similar domestic relations cases. We handle in a bench trial, in a criminal sense, we handle revocations of people who've been put on pretrial, not pretrial, but some sort of release program, except for parole. Parole is handled by the parole board itself. So probation violators, we just have the judge himself or herself makes that decision in circuit court. And we handle estates, we handle boundary line disputes. I don't know how many miles I've walked out in very thick land trying to find evidence of boundary lines. So one of the things that some judge told me, and it's true, to find old fence lines is to look for a line of cedars of a certain size, because birds would rest on the fence and deposit the seeds of the cedars, even though those cedars weren't even there when the fence was. But that's a good evidence that a fence used to be there. That's a little bit inside baseball talk there, a little bit too much.
That's a pretty good trick for finding those property lines.
Yeah, it is. But we do a lot of those things. And then we, of course, have the jury matters, which in the criminal context is always going to be a felony case. The jury trial right constitutionally extends to any case where the possible incarceration punishment is greater than 6 months. In Alabama, we extend it to just about everything. You can, cases out of Judge Terry's court can automatically, within 14 days, be appealed to my court. And I've had people appeal a speeding ticket and ask for a jury trial. It's not constitutionally required, but it is required by Alabama law to give them that right. So we believe in the right to trial by jury, even beyond what the Constitution says and requires. So we handle, of course, that goes, and Russ will certainly understand this, and you too, I'm sure, that it covers everything from the smallest felony, the smallest drug felony, to capital murder cases, of which we have the greatest number of capital murder cases pending in our circuit's history, which is something to be thankful for, that our circuit has not become known for having capital murders committed in it, but it's unfortunate that it has blossomed in the last several years. And we went years without a capital murder case. And then I made this, I don't believe in jinxes because I'm a person of faith, but if jinxes occurred, I opened my mouth and I observed, we haven't had a capital murder case in about 4 years. And then all of a sudden, pow, we had all of these capital murder cases. So that's jury trial work. Also in civil cases, they can, if the amount is over $75,000 in contest, or they can appeal, a small claims case to my circuit, a civil case. But most civil lawsuits, like car wreck cases and suits over business interest, those kind of things are tried in my court. And we have some very complicated civil cases. We have one pending now that is, it's got 28, I think, is the count of lawyers, and maybe that many parties. I'm trying to get them to prune the thing down, and millions and millions of dollars are being sought, and all the parties all the lawyers are well funded, which means it's going to be extensive litigation. So you never know what's going to walk in the door on a civil case. It could be something very interesting or something as simple as a car wreck case, which every case is very important to the people involved in it. And that is no more true than in the domestic relations area, where people are extremely invested in ideas like child custody and things of this nature. So that's about a good overview of what we do. I'm sure I'll think of something else, but there's an administrative side I'll be happy to talk about too at some point.
Well, I'm just trying to figure out. I mean, we think we may have a case that's going to have to come see you because somebody has stolen our asphalt out here on our road. So.
You're joking. You're joking.
Russ knows exactly what I'm talking about.
Did the road department start a repair and just not finish it, or? I shouldn't hear it. I shouldn't hear it because if you're going to bring it to my court, I shouldn't hear it.
There's more gravel out there than there is in the quarry right now. So. I had to spring that one on our county commission. I know they're doing the best they can with the money we got as a county, but
yeah.
I could have paved 2 more roads with what's in my ditch. So
bless your heart.
So you was talking about the caseload there. Typically, how many cases do go through the circuit court system? Maybe, let's just say, in a year.
In a year, typically, and these numbers have been holding steady since I was a judge, because our population, though it's dropped, in the latest census, people have maintained their level of litigiousness, if you want to use that word, of being willing to go to court over things instead of resolving their differences outside of court. So our numbers have remained the same in criminal cases. We run around 900 criminal cases. There are aberrations that are filed every year. And then domestic cases run about 400, 250 of which are new divorces. That number, thankfully, is actually going down, or has gone down for the last several years, the new divorces that are filed in the county. And then we have about 250 civil lawsuits of one form or another. I did the math trying to justify plea bargaining I spoke to a potential jury today, and was telling them that we didn't have any cases tried because all the cases had settled. And I defended plea bargaining because if we tried just 1 year's worth of filings, it would take 11 years for us to clear that docket. Wow. If no one settled. So 95+% settle, and the court system absolutely depends on that. The problem is that capital murder cases never settle, rarely settle, and they sort of clog up the system because people with the drug cases that are out on bond particularly won't settle their case, thinking that, I'm set on that trial docket, but that judge's got, he's going to handle that capital case before he handles my case. So I've been careful to set non-capital cases and let everybody know that they're equally vulnerable to being called to trial, and they then settle their case. I will say this about Judge Terry, and when I first came on the bench, there was a huge backlog, and it's nothing critical of Judge Rich. I mean, his wife was, he had a very good reason for the court system slowing down, at least his part of it. So what I did was I appointed, under the rules that apply to presiding circuit judges, Judge Terry is a special circuit judge. and she would hold jury court, and I would hold jury court. And we really cleared out the docket real quick doing that. So,
now those numbers that you gave us, now I heard you reference, years ago, the last few years. What about post COVID? I mean, are we during COVID and post COVID? What's the docket, the caseload looking like now?
Well, obviously, when we went into COVID, jury trials effective with the March order of the Supreme Court were stopped statewide. And we really weren't authorized to start jury trials again until September. So for me, I was right on the brink of a jury trial. And I think we missed 5 terms of court through that. Well, that's over half of our terms in a year. So that's half the jury trials. We couldn't get together in a large courtroom. My courtroom wasn't large enough for our plea dockets and things of that nature. Require, we'll have 150 people in that room. They're not socially distanced, obviously. And until that was lifted in late July by the governor, our hands were tied. What we did do, of course, was move to Zoom for all non-jury matters. I've tried divorces and all my pretrial things. I've taken guilty pleas in criminal cases. I've tried all my final revocation hearings, which we have those once a month, and they usually go from 8:30 to about 12:30 or so when we start having those. But so we were able to accomplish a lot of our regular bench trial work. But as far as the jury trials, they did get uncomfortably behind. Surprisingly, our throughput rate, though, is very good. In other words, throughput is how many cases you have relative to how many cases you have filed. Well, we disposed of 700 and some odd cases during that COVID year. And of course, we have 900 or so new ones filed. And when you have a throughput rate of that high relative to your new filings, that's about what we should expect. It should be a little higher than that, but that occurred because we were still taking guilty pleas. And the district attorney dismissed some cases, came up with some creative ways using Russ and what Russ does so effectively for his office in the diversion programs, was able to he's concerned. Our DA is concerned with making sure there's prompt justice. But it's not ever where I want it to be because I'm a perfectionist. I'm type A personality, and but I a long time ago realized I'm not the only moving part in this thing, and I just have to be patient and do my part as quickly as I can. But part of doing my part means, we don't think of speedy judges. We think of deliberate judges. Judges should be careful in their rulings and not just issue a ruling just to get the case off the docket.
Well, that being said, like you're saying, with COVID, things kind of got set back a little bit. How far behind are we in our court system thanks to our wonderful virus?
Well, this year I set extra dockets. Next year we're probably going back to the same number of dockets we had pre-COVID. If we are fully functional, you never know. I think this, and I'm not getting political about this. This COVID thing sets a very dangerous precedent in so many levels as far as the court system is concerned, and that is that we allow this medical emergency, if you want to call it that, to substantially affect the ability to conduct jury trials. And As long as that's out there, everything I'm about to tell you is got this big what if. The state health officer says we got an outbreak in December or January. I've always said that if we could get COVID down to flu, you know what I'm saying, where the infection rate is similar to flu, where the vaccinations, we still have people, thousands of people die from the flu every year, but we don't shut down the court system. And even though we all know that wearing masks probably would eliminate flu transmission better, we don't require that because of the common flu, which can be deadly as well. So with that proviso, as I was looking at the oldest cases we had on the docket, on this most recent docket, I think the oldest I disposed of this morning, and that was about 800 and some odd days old. That person had been on bond the entire time, and it was a minor drug offense. Mm-hmm. Of course, she had, continued it as many times as she could. She's on bonds. It wasn't bothering her. But I said, we're trying that case. It's the oldest one on our docket. Now, our capital cases, the one we've got set in October, is our second oldest capital case. And in each of our capital cases, the defendants have sat in jail for over 5 years. And the case we're going to try in October, the events actually occurred. I don't know everything about it. If I did, I wouldn't tell you, but I can give you a broad brush that the events predated the actual filing of the indictment by a period of months, if not a year and a half or so. So that is very regrettable. But when you have the defendants in a capital case, their lawyers putting forth all this argument on why they need more time to prepare, you have to weigh the competing interests, because if I deny their motion to continue, then what I'm going to hear if they're convicted in post-trial motions is that, well, the judge didn't give us a fair hearing. He didn't give us our day in court. He deprived us of this expert or deprived us of that. I'm saying this, knocking on wood. I've only been reversed twice. I've been appealed tens and tens of times. I put that rate up against anybody in the state. But part of it is because I was an appellate lawyer, and I know how to conduct my trials in such a way that there's nothing there to appeal when it's over with. So that's frustrating. I've set those cases for 3 years in a row, saying we're going to trial, and then they would all come up. Sometimes it's the state, and they have expert witness problems. And whenever we go to trial, I want everybody to have their fair and due process opportunity to present their case to those 12 decision makers. And I don't want anybody coming out of a court case saying, well, if the judge had just let us do this, we'd have had a different outcome. So it's, but we have a firm trial date set October 13 in October 18 in one of our capital murder cases. The oldest, the accused is being examined for mental competency. She has a diagnosed history of mental health problems, and she has a diagnosed history of being mentally challenged, almost to the level where you cannot execute them under the Atkins decision. And so, we had to postpone hers to the state psychiatrist and her psychiatrist all give us a report on her mental competency. So now I'm focused on the second oldest, and that's the one we're going to try October 13th. Then the next one, Judge Jones, Judge Deborah Jones. You've seen her ads. She's running for circuit court. And by the way, she's supposed to be here in December, and she asked me to ask you if she could talk to the to our committee. I said, well, I'm sure he's a very accommodating fellow. I'm sure he'll let us. But we may have a Christmas party date different than our normal meeting date. I don't know.
Yeah.
But she wants to talk to our committee. But she'll try that case first week of December, and it'll probably go on at least 2 weeks.
Yeah, she's good friends with Judge Terry as well, and I've been getting that now from two sides about her speaking for our executive committee. So we're gonna make that one happen, no problem.
Yeah, she's a good person, very good person.
Let's see. So, just like the county commission has audits and stuff, is there a system in place that does that for our court system as well, that kind of goes back and says, hey, this has been on the docket too long, or is it just all up to y'all as judges?
Well, we get monthly reports, and thanks to our electronic system, I can hit a button at any time and see cases that are pending and the oldest cases. And so we stay advised in that sense. We look at average days to disposition, which is sort of misleading in the fact that if we plead a case out, or it pleads out after years of pending, it actually then that goes into the numbers of how long a case has been pending. As long as the case is pending, it doesn't count against us. It counts against us once the case is over with, and they add up the number of days. So
it's kind of like the timer at the Taco Bell. They're trying to get you out as fast as you can.
It's true. Well, they do keep an eye on it. They don't. There are places, and when I practiced law, that it was not at all unusual to go 4 or 5 years for a simple divorce. And there was dysfunction in the Morgan County system at that time. They completely changed the judges. They were fighting among themselves, and all 3 left office, and we got 3 new judges. It still took years for them to get things running where it needs to. And then I know Madison County, Judge Ruth Ann Jones, who's presiding judge there, is a good friend of mine. We went through the National Judicial College together, and I think they have a backlog of 13,500 cases.
Wow.
They've got 6 courtrooms, and they don't have enough judges. They are shortchanged on judges, and they need more judges in Madison County. It now is the largest city in the state, as we all know. And Jefferson County has 20 circuit judges, and Madison County has 6.
Sounds like they need to put the help wanted sign out.
Yeah, they really do. But, I've gone over there and helped them, all of us, Judge Terry. Everybody tries to help them as much as our schedule will allow. But
now,
anyway,
you said that it was almost common for some divorces to go 5-6 years in those systems. I'll just be honest with you. I've heard rumors that we've had some uncontested that didn't even involve lawyers that went 2 and 3 years. Is there a way to speed that up, or what's missing? I have no clue about this stuff, right. So I'm asking a dumb question here.
Right. Well, I'd heard those rumors, during the course of the campaign, if you want to use that phrase. As neither one of us have qualified yet, but so I asked, I asked my clerk, because we have a tickler system on uncontested divorces. They hit the 31st day we sign the decree. I remember when I was appointed judge, my office, I used to like to say, is the southernmost law office in Decatur. It was down on 31. And Judge Thompson, who lived in Hartsville, that was on his way out. It was about 5:30. He came by, knocked on the door, and came in to congratulate me. And he said, "So what are you going to do? What's going to be your plan as circuit judge?" I said, "One thing I'm going to do is I'm going to get my orders out in divorce cases the very next day." And he laughed and laughed and laughed. He said, "Well, that sounds good. That assumes everybody's prepared you. They've given you all the paperwork. They've given you all the evidence to make a decision." And that rarely happens, even with lawyers. Mm-hmm. So I asked about the 2-year case. And there is a lawyer involved in that case, or was. We got it resolved, signed this week or last week. But he had been told time and time again, we had an extensive record, that we need one document which that lawyer should know that we need in every uncontested divorce. If we don't have all the paperwork, the case law says that divorce is void. Well, you got people around here getting married thinking they're divorced. That second marriage is void as a matter of law if the first marriage still exists.
Right.
And so, so I had set that case and brought him to court a full year ago and said, "Now, Mr. So-and-so, you need to get this in. This is holding this up. It's an uncontested divorce. I don't understand." And he says, "Well, I'll get it, Judge." And then I find out it's still pending. We did have an uncontested divorce. We do have uncontested divorces where lawyers are not filed or not in the case, but they use these internet packages, mm-hmm. and they rarely line up with Alabama law. So, and the other frustrating thing is we can't give legal advice by law. It's a crime, a felony for me to give legal advice, and it's a crime for any member of the court staff to give legal advice to any litigant. Mm-hmm. And so we can't tell these people without lawyers, well, here's what you need to do. I wish we could, yeah, but we can't. And all we can say is you're missing. And sometimes I will, in the form of an order, say this case is subject to disposal when X, Y, and Z are filed. That's not coaching them. I'm just issuing an order. You see what I'm saying? We had a case. People started calling that weren't involved in the case. And I had to issue a very stern order in that case that, we can't talk about other people's cases. Right. We're not allowed to discuss those things. But in that case, too, it was a lawyer who hadn't filed what was going on. And having practiced law, I know how easy it is to blame the judge. Mm-hmm. Oh, it's not me, it's the judge. What lawyer is going to want to say to his paying client, the reason your divorce is taking so long is because I haven't done my job. Yeah. You don't get many lawyers that frank and candid. But she apologized, the lawyer in that case, profusely, and got on the ball when I issued a 3-page, extremely strong order in that case. So we try to stay on it, and it's like I said, it's just a tickler system. I think with all our technology, we need to have it in our court system computer, because we have a 120-day cutoff for serving a complaint. If you don't serve your complaint within 120 days, a complaint's what starts a lawsuit or a divorce for that matter. Mm-hmm. Serving means give it to the other side so they can respond. If you don't do that within 120 days, we're going to dismiss your case without prejudice. And because, you're not pursuing your case, you're not prosecuting your case effectively. That we have that module in our AliCourt system. What I would like to see, because we do have a coding for an uncontested divorce in our AliCourt system, but what I'd like to see is AliCourt flag for us. Say, wait a minute, this is an uncontested divorce and there's no order entered, and bring it to our attention under one of the little blinking lights we have at the top of our screen on emergency orders and things like that. So I'm going to talk to my brother, who's head of the technology committee for the state court system. In fact, he's in Columbus, Ohio right now at a tech seminar, the latest technology. And so I give him as many tips as I can on things I think we need to improve. And some of them we've actually adopted. So,
well, that being said, talking about technology in our court systems and stuff, I know we see a lot of it on TV, but it's on TV. The use of technology in the courtroom, what's our current situation there? Are we moving forward in that? I mean, I see a lot of, you can just Google on YouTube, you see a lot of places where court systems are doing, like, they're not even bringing the prisoner to the courthouse now. They're just doing it over closed circuit TV or Zoom or something like that. Are we moving in that direction to be able to have that type of technology?
Oh, yes, very definitely. One of the things that Alabama, we always get chastised. One of the frustrating things about my law school, and I made some very good friends in my law school, but there were more people from the Northeast than the Southeast in my school, and they looked down on Alabama. I heard every redneck joke you can imagine until they got to know me. I wasn't so much of a redneck, but one of the things we're ahead of everybody else is in electronic filing. Many states still do not have electronic filing. We were the first state in the union to have electronic filing. And I remember going in 2009 to the National Judicial College, and I'd have to keep working on my cases while I was there at night, but I could get online and issue orders. And this judge from Nashville says, "What are you doing?" I was in class, I was issuing an order, some sort of emergency order in class, and he said, "What are you doing there?" I said, "I'm issuing an order." He said, "You're kidding me." I said, No, that's the way we do it in Alabama. He said, "Well, I just had to issue an emergency order. They had to fax it to a machine out here in Reno, and I had to sign it, and I had to fax it back." And he said, "We're not there yet." I said, "Well, we're blessed. We are." And that system, OLIS, which is Online Information Systems Company, has been slowly but surely picking up clients throughout. So on the filing end, we're way ahead of the game. That dovetails into the technology in the courtroom, because we do use Zoom in our courtrooms. Zoom for a criminal defendant's case is very helpful, because we don't have, unlike some places where the jails adjoins the court facility, ours requires somebody transporting prisoners 2 or 3 miles. And I may be exaggerating that. I've never trekked it, but it's a good distance. And that takes manpower from the jail. And Sheriff Sanders has, we've both lamented his lack of manpower that he absolutely needs to maintain proper security of that facility. And I don't like to take him out. So I still, even though post-COVID, I'm still going to use that system. And I'm blessed in that I was designated by the other judges, because nobody else wanted to work on this, I guess. But I've drafted a new rule of judicial administration, one of our court rules, Rule 47, that will permit us to use audio-video technologies for all court proceedings other than jury trials. And it cleans up all of it. Now, we're going to have to change some of the criminal court rules. We're going to have to change some of the civil court rules, even some of the rules of evidence. But now we'll have a reference point, an overarching rule that judges can hang their hat on. Now we conducted Zoom, or we are conducting Zoom, and we conducted Zoom in the past because there was a state of emergency, which allowed us to waive all of these requirements of in-court person attendance. There are constitutional issues on the confrontation clause with Zoom, but on the Miller resentencing that I had, he was in a prison, his prison facility, and we came up with an exhaustive way of making sure it was an open court proceeding. We sent out links to all the media that asked for a link, and we everybody that wanted to watch the Zoom proceeding live, they could, because one of the things our technology committee, they were working on Zoom before COVID was ever heard of, and they were going to roll it out anyway in the spring. So I don't know if you recall this, but Zoom got so overloaded because you got to have a license to host 100 or more people or something. And each judge has that license in the state now. Yeah. And so I think with Rule 47, which I meet with them on the 12th of October, the Supreme Court members, and I trust that they're going to adopt the rule, and we're going to be good to go for years to come. And our personal court system, we have 4K cameras in the court system, and under COVID money, we already had huge screens in our courtroom, but we got another screen, and I use some of our local court monies that I preside over to buy another 4K PTZ camera. You know what I'm talking about? One that can be moved every. Yeah. And so we have that mounted on top of this huge screen that we got from COVID money. And now what I anticipate is if I have a Zoom hearing, but somebody shows up at the courthouse and they weren't, they don't have a phone, they don't have a computer, they can't participate. Now we can put them in a room with that machine, and they can participate in the Zoom hearing with the rest of us. The second thing I want to do is, and it's just a matter of rewiring according to my technical people, but I want to make the jury lounge and the law library have a permanent monitor to watch court proceedings that are having to be socially distanced. We have the technology, as they used to say in $6 Million Man. We can rebuild them, but we can do this, and I think it's just going to make things like this. You take an uncontested divorce that the people haven't submitted everything. I can set that for a Zoom hearing and get those guys, if this rule passes, and get those guys on a quick Zoom hearing and just say, well, I don't see this. And they say, well, what is this? And I'll tell them. And now we have a new phenomenon called limited representation, where a lawyer can just draw up one piece of paper and be paid for that without being on the hook for the entire case. Yeah. And so I've been able to have emergency hearings, a lot shorter notice. So I really, my brother was the first one on our block with the Tandy computer. Do you remember the Tandy computers?
Yeah. And, I remember the Commodore 64 too. That one was my first
goodness. One. That was the Cadillac. We wanted a Commodore 64. But we coded in BASIC. Mostly I wrote out a code for RISC to regenerate. You have those large battles and I'm sorry, I'm sounding like a nerd now. But, I believed in technology. Of course, I started college in 78, and it was just coming on. So I took computer science, computer theory, as much computer as I could.
You disappeared there, Judge. Oh,
I know
there you
it
go.
told me my battery was going
Oh.
low. Am I still visible?
Yes, you are.
I got 20%, so I should be good.
Well, we'll try to hurry up through the rest of these because we're getting a little long here, anyways.
I'm long-winded, Daniel.
I've heard that from more than one person, so and
Oh,
from
man.
myself because I've sat and listened to you at the American Legion before. So
Oh, yes, that's right.
so three things here that involve the court system that I wanted to get your take on what they're currently the status is. Maybe if you see that coming in the future. Number one is drug court and how that's currently working. You know, I've heard that the person that was over it left, and it's kind of fizzled.
That's absolutely correct. The drug court was originally set up as a part of our community corrections program. And for years, it was the financial instrument through which community corrections survived. Community corrections lost money otherwise. Drug court paid the way. So I think Callie was with me on this because she was on the drug court team at the time. We both argued that, drug court ought to be by itself. It can be self-sustaining. But nobody else was online with that. The problem is that drug courts, while we use the word court, they're purely discretionary with the district attorney's office. District attorney can kill a drug court, and district attorney can create a drug court. All I do is I can kick people out of drug court, but I can't order someone into drug court by law. And they want that. The district attorneys wanted that when the law was passed so that some, I guess, liberal judge didn't put somebody in drug court they didn't think should be there. They wanted a final say over that. So Eric, I believe Eric really believes in drug court. And I've got some ideas of developing a drug court coordinator. And we recently just did our contract counsel bids, and one of the jobs to this counsel, to this lawyer, I said, your job is to restart drug court because you are now the drug court lawyer. So you're the chief advocate for the existence of drug court for your clients, for everybody in our system that qualifies. Because the thing is, in some counties, they are set up where they can put people in drug court, like right after they're arrested. That is the best time to put someone in drug court. They're at their lowest. They've probably never been as scared as they are in their lives, and they're ready for change. If it drags out, some people say, you don't need that drug court thing. You're just going to waste a lot of money. Just drag it out. You'll get probation or you'll get this. We need to get them at the stage of arrest. The problem is if they are indigent, we got to appoint them a lawyer. And that lawyer is not going to say, because our drug court system requires a guilty plea, they're going to be mighty reluctant to say on 2 days' notice, I just met this guy and I'm going to advise him to plead in the drug court. They're more worried about their law license, which rightly they should. But drug court, I'm a strong believer in. That deal with that came as a total surprise to me. That person retired. She gave me the letter of her on the day of her retirement. Apparently she had told others, but she had not told me. And I convened an emergency meeting of the board of the Community Corrections Department. I've interviewed 6 people, and some at the request of my political opponent, or at least one, and they've all rejected. 6 qualified people have rejected the position. And I don't want to just open the floodgates, because we'll get a lot of people try to apply that are not even remotely qualified. What I'm coming down to, and I've talked with the sheriff about this, but appointing a committee to basically do the hiring of our executive director of community corrections, and then go from there and have a separate committee that the DA has to approve of to restart our drug court. And I would love to have some people plead on our November docket into drug court and reboot it. I've got some ideas of changing the frequency. We were once a month. I want to go back to once a week and that kind of thing.
Mm-hmm. You were talking about community corrections there. I know the state is really starting to push community corrections and may even pass legislation to make it mandatory for each county to try to control prison population mostly.
Correct.
What's your thoughts on that?
Well, community corrections, if done right, can be very effective. But you've got to have evidence-based practices on deciding who goes into community corrections. There are certain tests that have been developed. One out of Ohio. Are you still there?
I'm still here. We're hearing you, just not seeing you.
Okay. All right. Well, I got to decline this call here. That's my daughter. So y'all are important if I decline a call from my daughter.
Appreciate that. She doesn't, but we do.
We think, community corrections, if it has tight supervision, is great. Mm-hmm. Where I realized we had a problem in our community corrections program is I would have somebody that I was sentencing. Okay, I was the one making the sentencing decision. Mm-hmm. And I would say, I'm going to place you on community corrections for 36 months, and then you go on probation for 48 months or whatever it is, however the sentence is structured. And a learned lawyer who's been around the system here in this county for many years said, Judge, respectfully, we think he needs, let me change that scenario. I would put him in probation. Okay, I would just go ahead and put him in straight probation. Mm-hmm. And the learned lawyer would say, well, we think he needs the more close supervision of community corrections. Mm-hmm. And I'm thinking, it doesn't take, you just miss a meeting and you're going to prison in community corrections. I mean, and yet you have to have 4 missed meetings in probation to violate your probation.
Sounds like that lawyer was just looking for another paycheck.
Well, yeah, sounds like it. But then I started seeing why we weren't supervising. So I started quarterly requiring every community corrections inmate to come to my court, and I wanted an honest report of where they stood, because I felt like there were those running the community corrections program that knew I was very strict about compliance and were afraid to tell me that somebody was out of compliance, because I would kick them out of the program, and community corrections wouldn't get a check from the Department of Corrections for that person. Gotcha. That's who pays for several of these community correction inmates. But I do believe in it. Lee County doesn't have community corrections because they have an extremely strong work release program. Mm-hmm. I would like to see a halfway house / work release building be a part of our community corrections program, with the sheriff, of course, being a part of that as well, and having tighter supervision over our community corrections inmates. Really, the whole community corrections program used to be the Supervised Intensive Release Program, the SIR program, out of the Department of Corrections. They would assign 2 individuals with the Department of Corrections to supervise. They would go out and meet with the proposed inmate's location. They look at the house. They would interview the people he's going to live with. They'd interview his job, and they'd make sure he was all appropriate before they would release him into the SIR program. And then they said, we're going to make SIR community corrections, and instead of the Department of Corrections paying for it, the brunt of the bill will be saddled upon the local counties. Nevertheless, I do believe in community corrections, and I'm not going to open call audition on your podcast, but if somebody that's qualified is interested, please approach me or Sheriff Sanders or Judge Terry or Eric Jett or Bobby Birch, if he's still chair of the county commission. Whoever the chairman is also on the committee.
Yeah.
But I've taken it up to this point, and we haven't gotten anywhere, so we got to do something different.
Russ, you had something?
Have y'all ever? I know this has never been done in Lawrence County at all, and I don't know of any other county that's been done in it. Has there ever been any consideration for a veterans court?
Yes, we've looked into that when I first became aware of it, because there are such peculiar and particular needs that veterans have that our criminal justice system just simply doesn't address well. So many of their medical needs, for instance, we need to be sure they're getting proper care for the free care that they're entitled to as a veteran. But veterans courts, the problem for us is volume. We don't, as our county, it just simply does not have the volume based on the census that we were able to take. What I'd like to see is cross circuit veterans courts, like Franklin County next door to us has virtually the same population we have. They have a single judge circuit. They're like this county. And I think we could very easily, between the two counties, have enough traffic to hold a veterans court or set up a veterans court. But the whole concept of crossing circuits is not permitted under the laws right now. So what I'd like to see is some sort of legislation proposed, and I know Proncy would be open to it, but as soon as I get this, that and mental health issues are something I'm going to work on long after I've been relieved of duty in this current job. I strongly believe in those programs.
One question that is on every Republican's mind when it comes to a judge, and I guess this will kind of help tie us up in a bow here and finishing things up. But when it comes to the Constitution, the rule of law, do you believe in the Constitution as a living document or as the Founding Fathers said, how it was written?
I believe, first of all, if I tell you this, you'll know that what the answer is. I am an Antonin Scalia enthusiast. In fact, I have here, I don't know if you can see it. This is a great book. If you've not gotten it yet, it's called Antonin Scalia Speaks, and it's collections of all his speeches. I am an originalist textualist. The law should be read as it, whatever law, I'm not just Constitution, but any statute should be read using the interpretations or the definitions of the words when the people passed it. Because that's the only thing that's gone through the test of democracy. If we start assigning meanings to words, like the Obergefell decision did, and that famously legalized same-sex marriages, we completely redefined the word marriage. The court just decided to do that. But if we start doing that, it makes the court the maker of law. The court is not the maker of law. We are merely the interpreter and applier of law to legal situations. We don't even carry out the law. That's the executive branch. That's the sheriff and the governor and the president. Our job is to merely interpret the law as applies to the case and controversies, as phrased from the Constitution, that come before us. And I believe that not as some sort of radical notion, as Justice Scalia would point out. That's the only notion we knew in the law up until the last 1950 and forward. And we created this concept out of the Due Process Clause of the 14th Amendment, which is intended as a procedural measure. It says before someone can be deprived of life, liberty, or property, they must have due process of law. Well, that's procedure. So that means a hearing before a detached tribunal and that kind of thing, notice of what the government's trying to do. Fundamental due process. Courts have taken that and expounded on that in Griswold versus Connecticut, and then Roe versus Wade is a primary example of using that clause. Sometimes they use the equal protection. Sometimes they develop this penumbra of rights. They say, well, we got the Fourth Amendment prohibition against unreasonable searches and seizures. That's really a privacy thing. So we have a right to privacy that's implicit in the Constitution. Well, what, Scalia's point, my point is fine. Let's have, I propose an amendment to the Constitution to give us a right to privacy. We do that and pass it, we are all in agreement. But if it's not in the document, I'm a firm believer in the way Justice Scalia and others like him, particularly in the Federalist Society, interpret the law. I think it's the only thing that makes sense. It takes away the burden for any judge to become a policymaker. I'm not in this business to be a policymaker. If I want to be a policymaker, there's a lot of retired judges that go on down to the State House, try to help judges out in our court system, and several state senators or former judges, et cetera. They shift roles when they do that, though. They become policymakers.
Right.
But as sitting judge, no, I'm extremely strict on that. I think it was a great loss when Antonin Scalia left us. Fortunately, we have YouTube, Daniel. Yep. I don't know if you've ever watched any of his debates, but he's phenomenal. And I encourage anybody to, that book is great. My brother has that book now and didn't think I had it. And I said, oh, I had it today. It came out. But anyway, I'm a big fan in being an originalist textualist, using the text as its original meanings were applied.
All right. Well, that clears that up for anybody that was wondering there. I know that's a big question as far as conservatives and Republicans are always wanting to know that about a judge.
Yes, sir. I want to know about it.
That being said, we're over an hour, so we're going to have to wrap this thing up because there's those of us that have that little bit of ADD that have started wandering off, so.
Yeah. Is Russ one of them?
I'm pretty happy.
We can't keep him under control. He's the opposite. So he's kind of like that little Energizer bunny. You wind him up and just let him go. So,
well, I've really enjoyed it. I love talking this thing, and a lot of this stuff I can't talk about in non-political years. And the law says, ethics rules say I can in political years. So I really appreciate this opportunity, Daniel and Russ, to have just a little bit of time to talk about things that mean a great deal to me, and I think to our county as well.
Well, I appreciate you coming on with us. Do our standard little asking here. If you're listening to us on YouTube, make sure you give us a thumbs up, hit subscribe. We want to thank you. We want you to be part of our podcast family here. If you're listening to us on any of the podcast services, make sure you give us a 5-star rating. Hit that subscribe button if you can. And that being said, I guess that'll kind of wrap things up for us. Again, thank you, Judge, for coming on with us.
Thank you.
Thanks, Judge.
Thank
Russ, Judge Craig, I'll give y'all the last words as we toodle on out.
Y'all be
you.
careful.
Everybody be careful, and I'll let Russ have the last word, but everybody be careful. God bless all of y'all.
Y'all be good.